Welcome. Welcome to the third and final day of the 2021 ACIL annual meeting. I hope you've been enjoying it so far. This morning, we're privileged to present the Society's Honorary Member Award to Judge Abdulkawi Ahmed Yusuf of the International Court of Justice. Following the presentation, Judge Yusuf will engage in a conversation with Professor Patricia Cavales on the rule of law at the international level, evolution and challenges. The Honorary Member Award is the Society's most enduring and established honor, first presented in 1906, the year of our founding. It recognizes an individual of American or other nationality who's rendered distinguished contributions or service in the field of international law. Upon the recommendation of the Honors Committee, the Executive Council has selected His Excellency Abdulkawi Ahmed Yusuf to receive this year's award. The committee's citation states that as President of the International Court of Justice, Judge Yusuf, and I quote, has provided energetic and effective leadership as the court has met the challenges of managing a large caseload in the time of COVID-19. Under his leadership, the court has amended its rules and practices to meet changing requirements, including by conducting hearings and reading of judgments by video link. As a teacher and scholar, he's been recognized for the range and depth of his numerous books and articles. His works range across fields as diverse as intellectual property, technology transfer and the TRIPS agreement, the role of African countries in the development and application of international law, self-determination, cultural heritage and cultural rights, the African Union and other international organizations, and international investment law and arbitration. Anyone who has had the privilege to see Judge Yusuf in action fully appreciates the invaluable impact he's had on the most cherished institution of the court. For his distinguished contributions and service to the field, the American Society of International Law is honored to present the 2021 Honorary Member Award to Judge Yusuf. Our deepest congratulations, Judge.
Distinguished guests, ladies and gentlemen, it's a great honor for me to receive today the 2021 Honorary Member Award of the American Society of International Law. I have always admired the work of ACIL in the promotion and dissemination of international law. I have also admired ACIL for serving as a model to other associations and societies of international law around the world. There are, of course, several examples I could give today to illustrate the role played by ACIL in the field of international law and the contribution its distinguished members have made to the development of international law, as well as the fact that it has served as an inspiration for other societies and associations. However, I will limit myself to two examples which are of personal interest to me. The first example concerns the International Court of Justice, of which, as you know, I'm a member. About 100 years ago, in 1920, one of the prominent members of the Advisory Committee of Jurists that was tasked to prepare the statute of the Permanent Court of International Justice was Mr. Elihu Root, the first president of the American Society of International Law. As you well know, the statute of our court is based on that of the Permanent Court of International Justice. Mr. Root was accompanied by his assistant, Mr. James Brown Scott, who was at the time the editor-in-chief of the American Journal of International Law, the official publication of ASIL. Both Mr. Root and Mr. Scott were among the founders of ASIL. They promoted the establishment of a permanent judicial body for the settlement of interstate disputes, even at the Second Hague Conference of 1907, when Mr. Root was still the Secretary of State and Mr. Brown Scott was legal advisor of the US State Department and a member of the US delegation to the 1907 conference. In 1920, Elihu Root was able to propose to the Advisory Committee of Jurists a formula for the election of judges to the court. This was one of the thorniest and most difficult issues facing the committee. The American Society of International Law can be proud of their achievements and of the great contribution they have made to the development of the rule of law at the international level. I say this because there can be no rule of law without a court to apply it. It is thanks to the vision and efforts of people like Elihu Root and James Brown Scott that we have today the International Court of Justice to apply the rule of law among states. The second example concerns the establishment of the first African International Law Association in 1986. We met in Lusaka, Zambia, in 1986 to create an African Association of International Law, a continental association. And of course, we drew inspiration from the American Society of International Law and other national societies that existed at the time. But our aim was to create a much bigger association because there were already some national societies in the African continent, such as those of Egypt and South Africa. That's why we thought we should not call it an African society, but an African Association of International Law. But there was also another reason why we chose to call it an association. This was to avoid having the same acronym as the American Society of International Law. So we went for AAIL instead of ASIL. However, I can assure you that in many respects, ASIL served as a model for the association we created in Lusaka, Zambia, in 1986. I would therefore like to take this opportunity to thank the members of the American Society of International Law for the great honor bestowed upon me today, but also for the contribution that ASIL has made to the promotion and dissemination of international law, which I hope will continue and will also include the defense of the international rule of law, which, as you know, now and then comes under attack in certain quarters. I thank you.
Judge Yusuf, thank you so much for your kind remarks and reminding us of the important legacy of the Society in support of the rule of law. And thank you so much for avoiding the acronym ASIL. Much appreciated. Our distinguished discussant this morning is Professor Patricia Cavales, a member of the United Nations International Law Commission and professor of international law at the Autonomous University of Lisbon. She serves as senior legal consultant on international law at the legal department of the Portuguese Ministry of Foreign Affairs and is a member of the Permanent Court of Arbitration. She previously served as the legal advisor of the Permanent Representation of Portugal to the European Union in Brussels, where she was responsible for overseeing the implementation of the Treaty of Lisbon and other institutional and legal matters. Professor, welcome, and we look forward to your conversation.
Thank you so much, Catherine, and thank you to ASIL for once again putting together such a wonderful event under these difficult times. It certainly is not as good as being in Washington, DC, but this is probably as good as it gets. And so thank you again and congratulations for such a successful event. I'm also very grateful to you, Catherine and Mark, for the invitation to conduct this conversation with Judge Yusuf on the occasion of the attribution of the Honorary Member Awards. And I warmly congratulate Judge Yusuf on receiving this award and on the wonderful remarks that he has just given us from the Great Hall of Justice in The Hague. But now we have the privilege of having him in this virtual room for a conversation on the topic of the rule of law at the international level, evolution and challenges. And I have to say that, as you said in your initial remarks, Catherine, anyone who has seen Judge Yusuf in action can really be only a great admirer of his wisdom, his depth of legal knowledge, and also I think a very good common sense and kindness. So I'm so privileged to be here today with you, Judge Yusuf, to conduct this conversation. I've had the pleasure since I've been a member of the Commission of seeing the remarks that you have given in the framework of the meetings of the Commission. There's a tradition that the President of the International Court of Justice comes on an annual basis to the meetings of the ILC. And the first time that you as President came to Geneva to the meeting of the ILC to give your remarks was precisely at the moment where the Commission was celebrating its 70th anniversary, and you gave outstanding remarks on the importance of the role of the Commission that were deeply appreciated. Last year also, 2019, we also had the occasion of having you, not last year, unfortunately, due to the pandemic, but the presence that you marked as President of the Court in the dialogue that we have among the Commission and the Court has been much appreciated. And I have to say also, as a personal note, those moments that we spent together in Geneva were also an occasion to reunite with our common mentor, Professor George Abissab, who I also take the opportunity to send our best regards. We've both been, Judge Yusuf and I, we've both been students of Professor Abissab in Geneva, and as he calls us, we are his children, ses enfants, as he normally says. So it's really a great honor for me to be here with you to reflect on the rule of the law and its evolution and challenges and your experience. So let me start with asking you a question that has to do with something you said last fall, in a panel where we had the occasion of being together on the commemoration of International Law Day at the Sixth Committee of the United Nations General Assembly meeting on the occasion of the 75th anniversary of the United Nations, where you stated that the legal order created under the auspices of the United Nations is the first at the international level to be based on the equal rights of peoples and the sovereignty, equality of all states. And you've also spoke of the development of the UN, under the UN Charter, of an all-inclusive international law. I wanted to ask you to expand a bit on those statements.
Oh, thank you very much, Patricia. And it is, of course, my pleasure to be with you today, actually, and to have this conversation with you. And I take this opportunity to thank also Catherine Amirfar for her kind words. Yes, of course, you are quite right. I always try to remind the younger generation that we have not always had the rule of law at the international level. And we have not always had an international law that had a universal vocation. That these are actually recent phenomena in the history of humankind. And they are things that we should all be proud of and that we should actually try to preserve for humanity in the future and to develop further. I say this because before the Charter of the United Nations, the legal order which prevailed at the international level was not a legal order which made room and accommodated all cultures, all civilizations, and the legal traditions of the peoples of different continents of the world. And we did not also have a rule at the international level because you can't have a rule of law at the domestic level or at the international level when war and violence is not prohibited. When the subjects of the law are not equal before the law. When, as far as international law is concerned, its sovereign equality is not recognized for all states and sovereign states. I can give you a few examples which are drawn from my experience also as an African international lawyer. And just to expand on that, let me say that what we had in the past, and particularly what we had before the League of Nations and the emergence, the gradual emergence of multilateralism, were regional systems of public law, regional systems of international law. So, of course, for example, as far as Europe is concerned, where we had the most developed, perhaps, system of public law, European writers refer to it as the public law of Europe. But some of them, of course, refer to it as international law or the law of nations. But the law to which they refer it as international law or the law of nations was not a law which was applicable to all the nations of the world, was not a law applicable to all the states of the world, was not a law which ensured equality before it for all peoples and for all nations. It was a law which discriminated against certain nations and certain states. And that's where I can give you the first example. Because in Africa, we had Ethiopia, which was an independent and sovereign state, and which luckily
escaped colonization by European powers in the 19th century. And actually, it defeated one European power which tried to subjugate it in 1896 at the Adwa, Battle of Adwa, or in Ethiopia, when the Ethiopian forces defeated the Italian army. But Ethiopia was neither a member of the League of Nations, nor was it one of the states that were invited to join the League of Nations. And you ask yourself why. And there was a debate after the establishment of the League of Nations, when Ethiopia actually applied for membership, whether Ethiopia should be admitted. And it's difficult to imagine for the younger generation today, but the argument of those who were in favor was actually that, well, it would actually help Ethiopia become more civilized to join the League of Nations. And for those who were against, Ethiopia was not, of course, civilized enough and did not meet the standard of civilization in order to be admitted to the League of Nations. So this was the kind of legal system which prevailed at the time. So there was neither equal rights of peoples at the international level or at the in international law, what was referred to at the time as international law, nor was there sovereign equality. And to give you another example, during the Versailles Conference, in which the covenant was being elaborated and negotiated, one of the proposals made by the Japanese delegation, and Japan was a newcomer also to the legal order at the time, because in the 19th century, Japan was not admitted to the magic circle of civilized nations. The proposal by the Japanese delegation was the inclusion of a clause in the covenant on the equality of races, by which I believe they meant equal rights of peoples at the time, but they formulated it otherwise, maybe. And this was not accepted by the majority of the states participating at the Versailles Conference. They objected to it. For them, equal rights of peoples was something which could not be accepted. The different nations, the different peoples of the world could not have equal rights. And so this was a system which I think one could not, of course, characterize as being a rule of law at the international level. And it was a system which, of course, one could not describe as being inclusive. And that is what I was trying to allude to when I made my speech. And thank you for reminding me of those remarks before the Sixth Committee of the General Assembly last year.
Thank you, Judge Yusuf. I think those are indeed important reminders for all of us, but also, of course, in particular for the younger generation that may take certain things for granted. And so it's always important to remind this evolution. And indeed, over your lifetime, you have witnessed this great evolution of international law, especially since the creation of the United Nations, which certainly marks a departure from the legal order that you were describing. And so from your personal point of view, what aspects of such evolution would you highlight? The prohibition of the use of force, the development of a universal system of protection of human rights, the appearance of a significant number of newly independent states due to the principle of self-determination, which in your personal view would be the aspects that you would highlight?
I always refer to a trinity of principles, which I consider to have revolutionized the legal order at the international level. The first two, which appear as principles and as objectives in the Charter of the United Nations, relate to the prohibition of the use of force in international relations and the principle of equal rights and self-determination of peoples. I think those are two groundbreaking principles. And the principle of equal rights and self-determination of people is for me, to a large extent, the source of human rights and people's rights under the Charter of the United Nations. But the third one, which was just mentioned in the preamble, but which gradually walked out of the preamble and came to occupy, actually, the center of the legal order, is the protection, the universal protection of human rights. So these are actually the three, and the second two, the principle of equal rights and self-determination, and the protection, the universal protection of human rights, are intrinsically linked. But also the prohibition of the use of force is linked to the two others. Because, finally, when we ask ourselves what is really the objective of all of this, and this discipline which we study and which we all exercise as a profession, whether it is law or international law, what is the objective? What's the purpose? The purpose, the final purpose, the final objective is the human being. And it's the well-being and the dignity of the human being and of the individual. And therefore, whether we talk about the prohibition of the use of force, which can actually take away the life, the dignity of human beings, or when we talk about equal rights of peoples and self-determination of peoples, which removes their oppression, their colonization, their enslavement, which was the lot of many peoples in the past, or whether we talk the protection of individual human rights, we are all talking about the same thing. And we are all moving towards the same objective. We all want to ensure the dignity and the well-being of the human person. So the evolution in the last 75 years of international law has actually been marked by this trinity of principles and rules. And it is through these principles that humanity has, to a large extent, avoided large-scale use of force in international relations. Unfortunately, we have here and there instances of use of force, and we have not had a third world war, which could, of course, be much more destructive than the first two world wars. But what is actually much more important is that there are certain areas around the world which have lived in relative peace over the last 70 years, and have, as a result, experienced an incredible growth and progress in both social and economic terms. But for me, again, from my personal point of view, the other example which you mentioned, the emergency at the international level of newly independent states, which is to a large extent thanks to the principle of equal rights and self-determination of peoples, which later became a rule of international law and is recognized today as a rule of customary international law. It is this emergency of the newly independent states which has actually marked for me the history of the last 75 years of humanity, and has contributed substantively to the development and evolution of international law. Not only to the development and evolution of international law, but actually to the reconceptualization of international law. Because what was referred, as I said, to as international law was in the past, most of the time, some sort of a regional legal system. But we have borrowed the techniques, some of the principles, some rules from those regional systems, and also from the legal traditions of the member states of the international community and of the United Nations, in order to reconceptualize and to develop the international legal system. And that is one of the things which I addressed during my speech to the 70th anniversary of the International Law Commission, because the International Law Commission played a very important role together with the international conferences, codification conferences, and progressive development conferences that have been convened by the United Nations in the last 50 years or 70 years. But so did our court, I must say, because I cannot not recognize, and I have to recognize the important role played by our court in this, in the development of international law. And I feel proud to read some of the judgments of the court and some of its advisory opinions, particularly after the 1960s, in the early 70s, or even late 60s with Barcelona Traction, the first advisory opinion on Namibia, the advisory opinion on Western Sahara. They actually all contributed to the consolidation of the rule of self-determination of peoples in international law, to its anchorage in international law as a customary rule of international law. So, of course, we have seen a lot of development, and I think that there has been a great positive, I should say, evolution of international law in the last 70 years.
Thank you, Judge Yusuf. We'll come back to the court and especially to current issues in the court and the future of the court in a moment. Well, let me just follow up. So after we discussed this significant impact that the UN had and the Charter and all the principles that flowed from the Charter and the practice of the UN that really changed the face of international law, and even the map, the international map, in terms of the appearance of a number of independent countries. And this, I fully agree with you, with this tripartite principles that are indissociable, and they're centered around the protection of the dignity of the human being. So a lot has been done, certainly, and we have a much more complete and robust, and as you said, also inclusive international law. But in spite of such evolution, there remain challenges to the rule of law at the international level at the present and also for the future. Which do you think are the greatest challenges in the present and for the future? Are those challenges mostly related to the maintenance of international peace and security, to the protection of human rights, sustainable development, to the protection of the environment, or perhaps to all of them?
I would say all the above, but I think that they are all interrelated because the maintenance of peace and security and the protection of human rights encompass also sustainable development and the protection of the environment. Unless we protect our environment and unless we engage in sustainable development, we might not be able to maintain peace and security on this planet. And of course, unless we protect the environment and unless we deal with the challenges that will arise from climate change, for example, and environmental degradation, human rights will suffer, and we will not be able, of course, to protect the human rights the way we would like to protect them. So they are all interrelated, and I think that we have to deal with all of them. I am, of course, an optimist because that's, I think, a professional defect for many international lawyers, and otherwise we would not be in international law. And therefore, I think that we can meet those challenges, but we have to prepare ourselves. And I think that we have some procedures, we have some mechanisms, we have some processes, and we have to make the best use of them. But the earlier we act, the better, because we cannot wait for a very, very long time. We have some legal frameworks, we have mechanisms, and I think that we can, by extension sometimes and by analogy, use the principles which are already in our toolbox to address some of the legal challenges which may arise from, for example, climate change, or which may arise from environmental degradation. And I think that at the same time, of course, we need to act more forcefully on the protection of human rights. But we can also, at the same time, be proud of the fact that we have commissions and courts for the protection of human rights in 3 continents today. We have a commission and a court in Africa. We have dealing with human and people's rights. We have the European Court of Human Rights. And we have a commission and court in the Americas. So I think that this is a major progress and advance. I would even characterize it as a key of human civilization. Because there was some debate when the Permanent Court of International Justice was being created, whether individuals should actually be given access to the Permanent Court of International Justice. But finally, that did not go through. And of course, the idea was that individual rights could always be protected through diplomatic protection. the rights, especially the rights of aliens, the rights of foreigners in other countries. And therefore, their governments could always take their grievances to the International Court of Justice. But of course, now we have all these human rights courts and commissions to which individuals can go in order to have their rights protected and to make sure that governments do not are not held accountable for the violation of their rights. So we need to develop the system of protection of the environment in a similar way in order to be able to deal with the future challenges arising from environmental degradation and climate change. And I think that can be done. And we are already on the way. And I feel that our court has actually contributed to a certain extent to the development of law in that field. And I'm very happy with that.
Judge Yusuf, I fully share your position as an optimist. I normally say that I'm an optimist by default, of course, a bit of a realist by experience, but I fully agree that I think in this profession, but also as a human being, we have to be optimistic and think that things will certainly get better, and we have the tools to do it. And some of the challenges that you've identified and how they're interlinked certainly are ones that make us be worried, but at the same time optimistic that the international community will find ways and solutions to make progress in all these areas. But now that you've mentioned also the role of the court, let us turn to your experience as judge of the International Court of Justice. And also, as Catherine said in her initial remarks, during your time at the ICJ, the court has been busier than ever. It has rendered a number of important judgments and advisory opinions. It also has been challenged with the unprecedented situation of the COVID-19 pandemic that made the court, under your guidance as president, to adapt very quickly to the new formats and to keep its important work going. I have a few questions about the courts and your experience. On initially, or on the first hand, what balance do you make of the your years in the ICJ so far, and how do you see the evolution of the court in a medium and long-term perspective? And then at the same time, you've started to address it a little bit already, but perhaps you could develop more. How has the court contributed to the affirmation of the rule of law at the international level, and how can it continue to do so? We have now, I think, about 15 minutes remaining, so please take your time to address these different points.
Well, thank you very much. You are, of course, right that the court has been busier than ever before in the last 2 decades. Actually, the court has received and dealt with almost the same number of cases as it had dealt with in its first 50 years of existence. So in the last 20 years, it has received as many cases and dealt with as many cases as it had dealt with during its first 50 years of existence. So you can see how things actually have evolved. And I think this is due to the trust and confidence placed in the court by the member states of the United Nations. This trust and confidence has been growing over the years. And I feel personally very fortunate that my term of office has coincided with this trend. And actually, I was able to serve at the court during this period because I don't think I would have enjoyed my work as much if I came to the court in the 1970s or even in the 1980s, you know. And I remember coming to The Hague as a student and meeting the president at the time of the International Court of Justice. And we asked him how many cases they had in the general roll of the court. And he said, we only have one case, you know, pending. And, you know, so that was not a good situation for the court. And it is a totally different court that we are dealing with today. And I think it's not by accident that we have this confidence and trust in the work of the court. It is because of the manner in which the court has acquitted itself of its judicial function as the principal judicial organ of the United Nations. It is due to the quality of the jurisprudence that the court has built over the years, the reliability on this jurisprudence, the manner in which this jurisprudence, and I will come in a minute, has also contributed to the progressive development of international law. So today, for example, at the court, we have 14 cases pending before the court. And during my first 2 years as president of the court in 2018, 2019, we received 8 cases at the court. So, of course, last year was a COVID year, was a year in which we all experienced this health crisis and this pandemic. So no new cases actually were received last year by the court. But this year, we have already received 1 new case. So we have 14 cases pending before the court. And they come from all the continents and all the regions of the world. And they actually, it is remarkable, the sheer breadth and diversity of the cases that are brought to the court and the importance of the legal issues lying at the heart of these cases. So you ask whether the court has actually contributed the manner in which, or you say the balance that we can make of my years at the ICJ. They have been extremely busy years, actually. And I have been on the bench now for 12 years, but I can tell you, I don't feel that I have been here for more than 3 or 4 years. I haven't seen the years pass. Absolutely not. I haven't felt them. You know, and that is because of the interest of the work, the challenges that the work actually produces. And of course, it is an extremely rewarding work. So you don't really feel that you are too busy, but we have been quite busy. We had to deal in the last 12 months now with this issue of the pandemic. And we were taken by surprise, of course, like all other international institutions and even domestic institutions. But of course, we were determined to ensure that the international justice and the judicial settlement of disputes would not come to a halt and would not be suspended by any health crisis or any type of crisis, that actually, because it is now more than ever that states want to see their cases before the court and their disputes before the court resolve it as quickly as possible. And so we could not simply cross our hands and say, okay, we wait until the end of the COVID-19 and then we continue, because we cannot hold hearings or deliberations, etc. So we immediately embarked on changing our methods of work. And we started with remote meetings, judicial meetings, administrative meetings, in which all judges participated. And we tried to master, all of us, the technologies necessary for such remote meetings. And we also adopted protocols, internal protocols for remote meetings, video link, video conferences, etc. And guidelines, we prepared guidelines for also remote hearings. And we amended our rules in order to reassure those who would appear before the court and tell them that we were not simply interpreting our rules, but we wanted to make clear to them that we were actually basing our decisions on new rules of the court, which were meant to respond to the new situation with which we were facing. So we did all of this, and we therefore prepared the ground, I think in about 45 days, for holding hearings, remote hearings. And we were able to hold remote hearings by the end of May 2021. And we have so far held 4 hearings by video, by hybrid, actually, hybrid hearings. Because we do not want, first of all, to hold virtual hearings. Because for us, the presence of the court in the Great Hall of Justice, and the fact that the parties can address the court in its usual sitting, and the symbolism of the court and of the judges sitting at the court itself is extremely important. We also did not want to exclude the possibility for the parties to address in person the judges of the court. And we, of course, allow parties, if they so wish, to come to the Great Hall of Justice, not in great numbers, but in a limited number of advocates, agents, and counsel to address the court in person. So we wanted to make sure that we could continue operating and working, but at the same time, we would not actually alter the nature of the court. And we would not have a court which appears only on a video links and screens, and which does not have a presence in the premises of the court itself. And that is what we wanted to ensure. And we have succeeded to do that. And we are very happy, actually, with the outcome, because we have not missed a beat. And we have continued with our work, whether it is the hearings, the deliberations, the judicial decisions, and we have issued several judgments since the COVID started. And so we continue with our work. How do I see the evolution of the court in a medium and long-term perspective? I hope that actually, and I am confident, I must say, that the trust in the work of the court will continue. Because I see how this trust is expressed and how this trust keeps growing. And I think that it will continue to play an extremely important role in the peaceful settlement of disputes. And I don't think that 30 or 40 years ago, we expected the judicial settlement of disputes to be as much at the center of the peaceful settlement of disputes among states as it is today. We thought that, political means of dispute settlement would continue to prevail. But today, the judicial settlement of disputes is playing an increasingly important role in international relations. And I think it is because of this growing trust and confidence in the work of the International Court of Justice. And the contribution of the court to the affirmation of the rule of law at the international level, I have already said a few words about self-determination. And I think that the last advisory opinion of the court on the Jagos Islands has actually further contributed to the development of the law of self-determination of peoples at the international level. But we cannot have a rule of law at the international level without a court which interprets the law and applies the rule of law. And this is the role that the court has been playing, despite the constraints, both judicial constraints, and administrative constraints. Judicial constraints in the sense that, of course, the jurisdiction of the court, and this is something that we all accept, and I think that this is something that personally I believe that should continue, is based on the consent of states. But we would have, of course, liked more states to accept and make a declaration of acceptance of the compulsory jurisdiction of the court. But what happens is that even those who accept the compulsory jurisdiction of the court include and insert a lot of reservations to their declarations, which act as a restraint on the jurisdiction of the court. And then, of course, on the other hand, we have the compromissory clauses in multilateral and bilateral conventions and treaties. And most of the cases which actually are now brought before the court are based on those compromissory clauses. But if you see now the trend, there is a growing trend not to include compromissory clauses on judicial settlement of disputes in multilateral conventions. So that's a constraint also. And administratively, just to say a few words, this is one of the least expensive international institutions in the world and the least expensive tribunal or court that has ever been established by states. We have only 100 staff members, and therefore we actually function with an extremely light structure. And of course, this can act also as a constraint.
Thank you, Judge Yusuf. Unfortunately, I think our time is up. Otherwise, we could have continued this conversation. I'm extremely privileged to have been able to conduct this conversation with you. I thank you for your important personal testimony regarding the rule of law at the international level, its evolution and challenges. And all that is left for me to do is to turn on to our dear president of ACIL, Catherine, for the closing of the session. Thank you very much.
I thank you.
Thank you both. I can't tell you how inspiring it's been to be a part of this conversation. Thank you to you, Judge Yusuf. And as you say, as international lawyers, what can we be but optimists? Congratulations again. And from all of us, thank you for everything that you have done in promotion of the rule of law. So everyone, please join us at 3 o'clock Eastern for the closing plenary, sponsored by the Asser Institute and the Municipality of The Hague. Immediately following the plenary will be what I think a time-honored tradition soon at 4 o'clock is a celebratory toast as we conclude the annual meeting. You can find the recipe for our official annual meeting cocktail on the annual meeting site, and we really look forward to raising our glasses with you then. Thank you so much.
Thank you very much.